So the amendment that is being proposed and that was moved before the federal cabinet is essentially an amendment to Section 500 of the Pakistan Penal Code, and that's one of the criminal defamation sections that exists on the book. Now, Section 500, obviously, I mean, if somebody is personally aggrieved by something, but one, just to sort of put it out there, the criminal defamation is something that world over, even the ICCPR has jurisprudence about this. So criminal defamation, one, is discouraged. There have been non-enforcement or repeal movements in various jurisdictions, and where these laws exist, for instance, non-enforcement of them. In Pakistan, however, not only does criminal defamation exist, it is applied and misapplied. So there's Section 500 of the PPC, we have Section 20 of PICA, which is still being used. We had an attempt previously for a similar amendment to be moved to Section 500, and then we also had the ordinance expanding PICA's ambit. Now, if somebody is personally aggrieved, we have civil defamation laws as well. And whether it's a parliamentarian, etc., you can use those laws, right? But even civil defamation can be used as a silencing tool. The point is that we have so many laws, they're just expanding the scope. Why do institutions need to be shielded from criticism? If there is something that is misinformation or something about an institution which is wrong, and we were hearing earlier about the whole fake news being weaponized to introduce more legislation, you have your offices, your PR wings, your media wings, you have platforms, websites, your spokespersons, you have television space, everything at your disposal. And this is the judiciary, the armed forces, the parliament. So why should scandalizing in all of these vague terms, I mean, even with contempt power, scandalizing of court in other jurisdictions does not exist. Why are we creating new and overbroad vague restrictions when we know that historically we have only, and not just historically, even presently, laws have only been put to use to silence critics and dissidents? So what I'll do is differentiate between banning and the futility of it, because, for example, when you ban websites, as we saw that recently when Wikipedia was blocked, right? One, the content, alleged offending content that you're seeking to impose, nobody knows about it till you bring it to light after imposing a ban. So you're doing this free publicity in PR and drawing people's attention to content you don't even know exists, right? So it's completely counterproductive in that sense. Secondly, there is obviously, I mean, you can't, for one piece of content that nobody knew about till you announced it, you are taking away access to so much else on the website, right? Whether it's Wikipedia, YouTube in the past, other sort of websites. And then secondly, who's sitting and making these decisions on what is offensive, what is not offensive? And that also is not done through any sort of legal due process. That aside, in terms of criminalizing more speech, and this is something that we should not be doing, but in terms of criminalizing more speech, it is useful for the state because you're able to exhaust people through the system. You're able to take such coercive action that some will have the ability to fight back, others will not. So there will be a silencing effect and a chilling effect, which will also, it's meant to be a lesson to the person, but also to others broadly, that we can go after you. Should you, and here's an example before you. So that is obviously the utility for the state to do this. But should we be criminalizing more speech? Absolutely not. We should actually, now we're at a stage where we need to review the laws that we have in the Penal Code and special statutes against the Constitution, and also where the world is at, and the covenants and conventions that we're a signatory to, and see how they're in conformity with them or not, and what are the contradictions, and we need to start getting rid, because it's not just about the language of the law or a bad law that exists. It's also the abuse of process, abuse of power that together then have a detrimental impact on civil liberties. I think it is critical to question why the Interior Ministry was the mover of this bill, why this bill was prepared in the first place, and why the PMLN and the PDM government is repeating what they were criticizing the predecessors PTI for. Have they learned no lessons in opposition, how laws were used against them and the kind of repression, and they only want to repeat the same and give a free hand? Because it's not just the politicians who get affected, it's also citizens, and the only thing that should happen with this bill is that it should be taken back.